It's time to focus on seniors with Helping Seniors TV. The television show designed to make you aware of senior issues and needs, as well as to acquaint you with the resources available to help you age in place and with dignity. Now, here's your host, Joe Steckler.
I'm Joe Steckler, and welcome to Helping Seniors, the television arm of Helping Seniors of Brevard County. Our show is designed to provide you with information on how to develop your own aging and care plans. Our topic today is attorneys and estate planning. Joining me is Scott Dixon of Widerman Malek Attorneys at Law. Welcome, Scott.
Well, thank you, Joe. Good to be here.
I've known you since you were a very, very young man.
Since I was a lowly paralegal.
Yeah, I guess right. You worked for your dad.
Yes.
And Scott's father, Bill Dixon, and I were very close in founding the current Alzheimer's Foundation. And Bill, I remember the time, Scott, that your dad and I went to Chicago to tell the National Alzheimer's Association we were no longer going to be a part of it because they were charging excessive dues. And your dad agreed that the money that we raised in Brevard County to help people needed to stay in Brevard County and help people.
Absolutely.
Yeah. And that's what this show is. That's what Helping Seniors is. Helping Seniors is designed to provide information, education, and connection to resources. And your firm of Widerman Malek is now part of our network. Absolutely. And that's why I felt it was so important that our viewers get to know all of our sponsors, because all of our sponsors are organizations that help promote the cause of seniors.
Correct.
So, having said that, what are some of the general duties of an attorney, and maybe just tie that sort of together with what Widerman Malek does? What type of law do you all practice?
Certainly. Well, generally attorneys are representing others. So when it comes to litigation, if you have a dispute with somebody else or a business, we would represent you in that dispute and try and come to a resolution, hopefully that's in your favor. That's why we're representing you. So that's one aspect of being an attorney. Another aspect is more what I do, and that is estate planning. And that would be more of a counselor. You may have also referred to attorney as a counselor at law, and that would be to advise you on ways to plan for the future and things of that nature. Fortunately, we joined the firm of Widerman Malek about a year ago, and it is one of the premier law firms in Brevard County, one of the biggest. And as a result, we can now expand the services that we offer to clients. We cover patents, trademarks, copyrights, litigation, foreclosure defense, patent defense, and all sorts of government, employment law, pretty much any legal need that a client may have. Either we can take care of it with our firm, or in the few areas of law that we don't do, we certainly have relationship with other fine law firms that we can refer you to.
I called Scott on a matter of a client called our office and asked a question, and I didn't know the answer. So I called Scott, and Scott made a referral to another attorney of a different firm because it was the type of law they didn't practice. So I think it's important. Networking, Scott, is so important. But you used a buzzword in there that, and I don't know how much you know about it, but you mentioned foreclosure law.
Correct.
Is in the current environment in which we're living, are more people finding a need to avail themselves of attorneys that can help them fight foreclosures?
Oh, absolutely. We have a situation in Brevard County, and I happen to know the judge that handles foreclosure. And what he was telling me is that after we've gone through all the legal processes and we're ready to get a final judgment of foreclosure, if we were to call his assistant and ask for a hearing, it would be 3 or 4 months before we could even get that hearing, the courts are so backlogged with foreclosures in this county because of people who are underwater in their mortgage or the housing crisis or whatever the reason. So it is definitely a big need in Brevard County, and the advantage of having a lawyer represent you for foreclosure defense could be to try and renegotiate the mortgage, or if it doesn't appear that the mortgage can be renegotiated, it may consist of helping to work out a deal with the bank so that you can stay longer and give yourself opportunity to find an alternative housing situation.
That's a very important point. By using an attorney that's very, very familiar in this field of law, are able to make the law work for you.
Exactly. Yeah, and that really is the area of Scott Widerman, one of our senior partners in our firm. And pretty much what he would do is help work with the court to give you that extra time that you need. A lot of people mistakenly think that they get served with foreclosure papers and they got to be out next week, and they panic. And as a result of the panic, maybe they'll make unwise decisions and move prematurely and get into a situation that isn't to their best advantage. But with the time being delayed, you're able to look at all your options and come up with the best plan for you.
I'll jump ahead in my questions I was going to ask you today, because you've sort of worked into another area and talking about the correct use of an attorney. I think that translates further into the use of office depot documents,
Yes,
as opposed to the use of a qualified attorney that understands all the quirks and everything of the law. Perhaps you could help just give a slight dissertation,
Yes,
short, on what I'm talking about, because I know you know what I am referring to.
short dissertation for a lawyer?
Yes, short.
Okay.
Yeah, okay.
Okay.
Your dad could never do it. I know
I
that.
could never
I know
do
you
it
talked
either,
to
but I'll do my best for you. One of the biggest advantages really is the counsel. And as I said, my area of law, I prefer the term counselor at law. Anybody can go buy a form, but especially when it comes to a will or a power of attorney or a healthcare surrogate, you only get one chance to do it. If you do it wrong, you usually cannot go back and correct the mistake. Obviously, in the case of a will, we find out after you've died, or in the case of a power of attorney, often we're finding out if you're incapacitated and you can't go cure the fault.
What do you mean when you say a mistake?
Well, for example, if a will is not executed properly, maybe you're naming a friend who lives out of state as the personal representative. That would be a common thing to do, especially people who have moved here from up north. Well, according to Florida law, their friend cannot serve as their representative when their estate needs to go through probate. So the will may be valid, but because they haven't gotten the proper counsel, it's completely useless because we can't carry out their wishes.
Why couldn't a friend, if they're named, why couldn't they serve as?
Because it's a Florida law requirement. Our statutes require that your personal representative is a Florida resident, and the only exception is that if they're related by blood or marriage, then they can serve. But if you name a corporation that's foreign or a friend from up north that's foreign, Florida law will forbid them from serving. And you wouldn't know that if you just go pick up a form. You won't have the counsel that goes with it.
Was this part of the big change that came about in 2011?
No, sir. This has been law for a while. The big change in 2011, in October of 2011, had to do with powers of attorney. And the state of Florida, they really did a major overhaul. And what they did is they opted into what's commonly called the Uniform Powers of Attorney Act. And the first thing to know about them is that they're anything but uniform. The idea
I want you to talk about this.
Yeah. What uniform powers are is a group of lawyers come up with what they believe should be a standard format that all states would follow. But because of Article 10 of our Constitution, states still have sovereignty. So they get to elect whether they adopt those changes or not. And so we're going to take the basic form and we're going to modify it to make it work for Florida. One of the biggest advantages to the power of attorney with the way it currently is, if you've changed it with the new changes, of course, is that it gets into a lot more detail. Our old forms were about 5 pages, our new forms are about 17 pages, because we're getting into all the details detailing the powers that you can give your agent. Another thing that the change brought about, which I think is an excellent change, is that you can tailor the power of attorney to your particular wishes. For example, you may want to allow your power of attorney or your agent to make gifts and to pay your bills, but not to change the beneficiary on your IRA or not to sell your home. So you can say yes or no to each individual power and give your agent just the powers that you want them to have.
In your experience and working with this, let's say you've got a list, shopping list like this. Do you find, is there another section at the very bottom that says additional powers? Have you found that the Uniform Act covers every contingency, or other things that you need to add in?
I think it covered just about everything. And because it's uniform, then it's also helpful that if you need to use it in a different state, say, for example, your bank is headquartered in South Dakota. Well, if South Dakota, has opted into a similar power of attorney law, and they have, then they're going to recognize the basic form of the document, even though it's going to reference Florida statutes.
But if you went to, I'm not picking on Office Depot, any stationery store, and you picked up a 2-page durable power of attorney, you wouldn't get.
Oh, no, sir.
You wouldn't do it.
You would not get that at all. And in fact, an interesting exercise, and not to pick on Legalzoom, but I think they have a lot of clout and people are familiar with them. I would encourage you to go on their website and look at their disclaimer. It basically says, we're not guaranteeing anything that you may buy from us, and we're not guaranteeing that it's consistent with current law.
They say that.
Absolutely, it's in their disclaimer. And this is not legal advice. We do not represent you.
As an estate planner or counselor, when people think about the durable power of attorney, my biggest concern throughout my post-military work has been primarily with dementia patients. And I found so many cases where people thought they had protected themselves with the durable power of attorney, yet there wasn't a specific power accruing to them that would pass beyond a person going from a normal to a mental state or mental
Yes.
incapacity. What is the great danger there, Scott, in trying to do estate planning and avoiding pitfalls? What kind of advice would you give our viewers as they get older? What are some of the things you tell them to look for?
Well, specifically addressing what you just referenced, and that's why going to pick out a form, you may not even get the right form. For example, if you do not have any provisions, in the event of your incapacity, your power of attorney is void. The idea being that if you were competent and you saw that your agent was misusing the power, you can revoke it and do another one. Well, if you've lost the capacity to revoke it, then the law will step in to protect you and do that. So if you want it to be durable, and that's the key difference, a durable power of attorney, what the durability clause says is that I understand the risk, but even if I become incompetent or incapacitated, I still want this document to be good, and I understand what the provisions mean.
Is that where the two words revocable and irrevocable come in?
Well, that typically is dealing more with trusts. although a power of attorney, as any document, you can revoke. Generally, with a power of attorney, you do not do an irrevocable one.
Okay.
Because you want to be able to change it if they misuse the power.
Okay, let's shift over to trust, because that's part of estate planning.
Correct.
When you get into this business of revocable and irrevocable trust, what is the difference? What does that mean?
Great question. The key difference is the ability to change it or get rid of it. A revocable trust, we're usually preparing as an alternative to a probate. If you have a will, upon your death, your estate will go through probate.
Right.
With a trust, your estate is going through a trust administration. It's a different process. We still need some process, and that's what we do in a consultation with a client is we compare the differences and let them choose what is better for them. A irrevocable trust is something that you can never change. Once you do it, you cannot go back and undo it.
Why would a person do that?
There's really two main reasons that you would do it. One common irrevocable trust is a charitable trust. So, for example, if you wanted to guarantee an income stream for your retirement and you had a highly appreciated asset, then you may make the decision to donate that asset to a charity with the understanding that they would give you an income stream for the rest of your life, and then they would get the remainder when you die. Well, in order to get the tax break now, that gift must be irrevocable or the IRS will not give you the tax break. So you can take a tax bomb, like a highly appreciated stock or an IRA or a 401k, and instead turn it into a tax break and a higher income stream for life. So because you're getting that benefit of the tax break, you're willing to make it an irrevocable gift.
What happens if you do an irrevocable trust, you give it to a charity, and a charity fails?
Well, the good news is that we have right here in Brevard County the Community Foundation for Brevard.
Right.
And they are committed to keeping the dollars in Brevard County the same way Helping Seniors for Brevard is, except there are greater amount of charities involved with them. It could be anything from schools to Save the Whales or Save the Pelicans or anything like that. But they would control the money. It wouldn't go directly to the charity. We would actually do the charitable annuity with our own foundation that we're controlling, and then we dole out the money according to our own advisors.
So I guess the law would stipulate that they could not give out more money than a donation would be worth.
Exactly.
So how can you guarantee an income? Can you guarantee a level of income for life?
Yes, sir. What you can do is you can do it one of two ways, and the IRS, of course, is going to have regulations because you have gotten a tax write-off. So they're going to limit you to anywhere between 5 and 7% return. So you have the money invested generating a return. So in most cases, you're only drawing on the income and you're not touching the principal. So you can set it up in a way where, for example, I want $1,000 a month. And some years the investment will make a little bit more, and some years the investment will make a little bit less.
Okay.
But it's going to even out. Another way you can do it is you can say, just give me 5%. Whatever the value of it is, they recalibrate it every January 1. They figure up the value that year, and you'll get an income stream for the next year based on the value at the beginning of the year.
In all the TV shows we've done about estate planning, radio shows, we have never, ever talked about this part of the trust and charitable giving. And this is why it's so important, because every time we do, I can take the same show and do it with 5 attorneys and get different.
And you'll get 7 opinions.
Yeah, I can get different things. But they're all important.
Right, because we each have things that are kind of near and dear to our hearts. And I believe that charity should stay here in our county. And there's so many powerful tools that you can take a tax bomb and turn it into a wonderful gift to our community and still help yourself in retirement. It's such a powerful tool.
And my devious mind is thinking about the different types of law that the firm of Widerman Malek practices and how those different areas could probably assist you as an estate counselor in doing what you're trying to do, because no area of law is independent of another area of law.
Absolutely.
They all tie together.
Every day I'm going to talk to one of the other attorneys in our firm and have an issue that we need to bounce off each other.
Okay. There are two areas I still want to talk about. The first one are second marriages in Florida law, and the other one is scams. I want to talk about that for you. So don't you let me run out of time. Let's talk about second marriages.
Yes.
And why it's important for our viewers to know more about that, especially in Florida.
Yes, it's especially important to do a good, sound estate plan in the case of a second marriage where you each have children from a previous marriage. And here's why. A lot of people, they unfortunately get their advice from the bank teller, who will tell them, just own everything jointly and then put transfer on death when you die. And if in a perfect world that may work, but one thing we're sure of is that change will always happen. So let's say that you have a husband and wife, and they each have 2 children from prior marriages. Okay, and they own everything jointly. And typically us guys die first, so let's take the scenario, we die first, and everything will go to our wife because we're joint owners on that account. Now when our wife dies, if she has not done a will, then everything will go to her heirs at law, because that's what the Florida statutes will do.
When you say heirs, what does that mean?
Heirs at law will be the next closest to you. So if she has remarried, which is a whole nother problem, now she's taking your money into her new marriage, but assuming she didn't, then her heirs would be her children, then her parents, then her siblings, then her nieces and nephews, etc. And so it will go till it finds the next class of relationship that's closest in blood. So you could find that you take and you merge your households and each of you contribute half, but if she's the one that dies last, then everything is going to her children or her grandchildren or her closest heirs, and your family gets nothing without any planning.
All right, not to take anything from second marriage, because I know people that have not entered into a second marriage simply because their children didn't want to lose their assets.
Right.
And I think that's wrong. I think that the parents should be the ones that their happiness should be the most important.
Absolutely.
The children should prepare themselves. However, having said that, how, in a second marriage, how can you prevent certain things like this happening?
Right. Well, one way is to use wills or trusts, and you have a common plan that you come up together, and you divide everything according to 50-50, that when we die, everything goes to our kids. If we're concerned about the kids, sometimes, going back to the incapacity situation, it may be a greedy child that is the guardian of your wife after you've died, and now they're in control of the money. So there's all sorts of things we need to be concerned about. So we may, if we think that is a issue that we need to be concerned about, some couples have chosen to keep the assets separate rather than combining them so that upon their death, their money goes to their children. Another option that sometimes is available is to designate a life insurance policy to go to your children. In essence, buy your children out, so that when you die, your children get what they would have gotten in inheritance anyway, and your spouse still has the rest to live on, and you're taking care of both your children and your spouse.
Okay. So when you talk to people on estate counseling, these are the type of things you point out to them.
Right, something you're never going to get from a form.
That's exactly right. My last question, we're almost out of time. Scams.
Scams.
What is your, and the reason I'm asking is because I am very recently aware of a lady that was built by an outside firm claiming they were from Publishers Clearinghouse, They took this poor woman to the tune of $70,000.
Oh, man.
And she kept feeding the money
Yep.
because everything they sent to her looked official.
Sure.
And I want to make a comment, and then you add to it.
Okay.
My opinion, if you get a phone call where somebody asks you for money, hang up the phone. If you want to give money, find out a local cause you can give the money to, or somebody through your church that you trust. You know they're going to use the money for the designated purpose that you give it for.
Absolutely.
Barring that, I don't like to use telemarketing because the money goes to pay the telemarketers.
Correct.
I know they have to earn a living, Scott, but I don't want them to earn a living off the money I've earned. I want it to be used for a good cause.
And usually they're taking the lion's share of what you give as well.
Yeah. Now, what else would you add about scams?
Yes. Unfortunately, our seniors are the biggest targets.
Yeah.
They're the ones usually at home to answer the phone, first of all. But one thing with an inbound call, never ever give a credit card, never ever give your social security number, never ever give your address. Do not give out any information if you do not know where that call came from. If they're a scammer, they can take that information and do all sorts of havoc on you.
I know. And if somebody calls and says, open this email, don't open it.
Never
unless
open that email.
Yeah, if you open the email, I forget the name of the scam that was worked on me, but it put a virus in my computer that it took 3 hours to get the virus off the computer.
Absolutely.
Yeah.
Yeah, there's a lot of evil out there preying on our seniors, and we need to be aware.